Good afternoon, everyone, and welcome to today's webinar. I'm Callie Waterhouse with the Arizona Association of Realtors, and we're thrilled that you have chosen to join us today for Property Manager's Duty to Disclose with Denise Holliday. If you've joined us before, welcome back, and if this is your first webinar with us, welcome, welcome. And so we just want you to know that today's webinar you can expect to learn, to be entertained, and to get your property management questions answered. I got to tell you, Denise is definitely one of our most favorite, most requested, most sought after webinar presenters. And Denise is an attorney at law engaged in landlord-tenant law since 1996, a justice of the peace pro tem since 2000, Superior Court pro tem since 2002. She is co-author of the website drevictor.com. She is also one of our instructors here at AAR, and one of the most popular classes is our Property Management Boot Camp and our Advanced Property Management Boot Camp. So with all of that being said, welcome, Denise.
Well, hello, everybody. After that, I'm not sure I can live up to all those expectations, but I will do my best. So today we're going to talk about disclosure. All of you, if you're a licensee, you know you're required to take a disclosure class for your real estate licensing credits. We're going to talk about, in a real abbreviated format, kind of what does it mean to property managers and what are you required to disclose. We all know that your first requirement or your first duty is to put whatever you're going to disclose in writing, more than just shaking someone's hand, letting them know whatever needs to be disclosed needs to be done and documented so that you can prove that you actually met that obligation. So disclose, we know what that means: to expose, reveal, divulge, make known, tell someone, share the knowledge. The interesting thing is, when we're dealing with property management, it's not just your client that you would normally think about disclosing to. It's actually and the tenant who's part of that lease, or a prospective tenant, and that's where we deal with the duty to the public at large. We have some special statutes that talk about disclosure and a realtor's duty to disclose under Title 32. And if you don't disclose, you can have your license revoked or suspended. It's a really big deal. We have had more and more people in trouble for this type of issue than we would like to see. And I tend to think that most of the time it's that they're just not familiar with what exactly they're required to do. In fact, recently, last week, I had a property manager who was in trouble because the tenant wrongfully believed that they were representing them too, because the property manager didn't clearly disclose that they represented the landlord only. And that's one of the examples we frequently get into in a landlord-tenant relationship. So besides this particular statute that talks about making false or misleading representations, Article 2 of our Code of Ethics also addresses what we are required to do and what we shall avoid. I can tell you I very rarely see out-and-out misrepresentation, but exaggeration seems to be one of the biggest issues we deal with. You talk about what a beautiful view it has of those beautiful mountains. Of course, it's across the street, and you'd have to sit on the sidewalk and to watch that sun set. And that's clearly an exaggeration of what that person will experience when they rent or buy that house. Concealment's another area we deal with, but remember, you don't have a duty to investigate. It's just your duty to now reveal or disclose any information you came upon or should have come upon. We have a final statute we're going to just roughly touch, R4281101. This is you're required to disclose in writing to all other parties any information that materially or adversely affects the consideration be paid by any party. Why is that important? The very first question I see is that someone had a question about the uprise of VRBOs. And is that something that we need to be looking about or thinking about in our residential transactions, especially with our tenants? And I can tell you, I think it would be very relevant to me if I was going to rent a house and there are 3 VRBO homes on this street where these people are going to come in, usually for a short weekend, usually using all the things outside in a manner that the rest of us don't always use because they're only there for a short period of time. And given that particular issue, that may be a material issue and maybe something that needs to be disclosed before you actually sit down and write a lease. So yes, I would say that's a new and upcoming issue. one of the first issues that I want to talk about that is clear in all of our transactions is to be very clear about your disclosure to everyone, the public at large, the name of your brokerage. And that means not only on your sign, that not only on your business cards, but also if you are talking to anyone about what you do for a living, even on the internet, on your Facebook page. If you're talking about what you do and where you work and soliciting business, you need to also include the name of your brokerage in any of that social media so that everyone's clear that you're representing your broker in a proper manner. You also need to notify the public at large if you are an agent and also the owner of the property. That also includes if you are a member of the LLC that owns that particular house. You're required to disclose that up front in all of your advertising materials and in the contract itself. As for property management, you have a special duty to disclose prior, and here's the key, before you actually enter into a lease, you need to make the information available to the public at large, the property information, the specifics about the property, the square footage and what amenities are included, the typical things you see on an MLS listing, but also what's your application fee? Is it per person? Is it refundable? If you're going to take multiple applications, are you going to run all of them and charge all of those people when there's only one house? Or are you going to take one at a time and just run one application on its own against itself? You need to disclose that ahead of time. One of the complaints we've had in the last couple of years, especially the last 6 months or so, is that the market's really tight and that you are taking maybe 5, 10, 20 applications on the same house. You are now making a profit because you're running all those applications. It's not costing you that amount of money to run all those applications, and then you're pocketing the difference. So did you disclose that to the public that you're taking multiple applications and multiple application fees? Or did you disclose in your property management agreement that you may be making some extra money on the different application fees that you're taking even though there's only one house? What are the deposits? And that means all of the deposits, the refundable deposits, the non-refundable deposits, and the other fees. I was looking at a lease out in Flagstaff where the monthly rent wasn't that bad and the regular deposits wasn't really an issue, but it also required a parking fee, a parking permit fee that all of the occupants of this house had to have. The condo only came with one. The parking fee was $500 a semester per car. This is a big house, 4-bedroom house. You've got 8 college students all living in that house. Only one car got the parking permit. All the other ones had to pay it for a whole entire school year. It's $1,000. That's an additional $7,000 in additional fees that had not been disclosed. Clearly that would be a disclosure violation. The last part is the basic terms of the lease. It would be let them know what the length of the lease would be, what the rents will be, if there's any kind of some unique charges that you wouldn't normally see, like HOA fees, or anything else that, like, for instance, if there's not some trash services and you might have to maybe take this particular debris to the dump. The next issue is a really big issue. If you are in this field, you probably are very aware of what we call ban the box. There is a new movement, came out after the HUD document that was issued in April. It's not a memorandum, it's a guidance, but it strongly urges all property managers to immediately stop banning all felonies. That means typically, as you guys know, in our industry, we used to have a policy where we would just run criminal first. If you ever had a felony, you automatically were disqualified. It was the fastest and cheapest way to cut down on the number of applications and really focus on somebody you're looking for. The April memorandum or paper said that it was inappropriate to continue to have a complete ban of all felonies. Their discussion is that there's a disparate impact to certain ethnic groups and different nations of origin that potentially were impacted disproportionately, either convictions or lengths of sentences. And as such, in order for you to now have any kind of felony provision in your application, you needed to disclose it up front. You need to weigh what types of felonies you were going to allow or disallow. You need to weigh the amount of time that the crime happened, when it was sentenced, and the amount of time after the completion of the full sentence, which it would include probation or parole. They also would like us to take a look at allowing the tenant to submit mitigating factors. If you're using an AAR application, you already have included that. Luckily, AAR thought of that many years ago. On the second page of an application, it says if there's any other information you'd like us to consider as part of your application, feel free to present that information with your application. We believe that'll resolve a lot of the concerns, but you need to think about, especially if you're using a third-party vendor, specifically disclosing what felonies are complete bans. For instance, if you are a registered sex offender or have participated in, say, maybe the manufacture and selling of methamphetamines, and then which felonies are going to be some kind of limit, some time frame since they completed that crime and then completed their sentence. The full sentence, which once again is the probation or parole. But you need to do that immediately. If you have not, you need to have conversations with any of your licensees, including any of your staff members that might be answering the phone. I believe that there are a series of testers out right now. We know that one of the agencies, local agencies, got one of the largest grants they've ever had to send out and test this, send in people of different races and say, will you consider me even though I've had a felony? So be really careful. That's a hot new issue. If you are not familiar what we're talking about, you need to get into a really good fair housing class. I also know that AAR is putting on another webinar coming up at the end of the month. It'll be October 26th. So you want to check in and pay attention to that particular webinar too, where we'll spend the entire time talking about that particular issue.
Denise, Angie has a question. She's wondering if these new guidelines also apply to commercial leasing.
Great question. I can tell you they did not specifically say that it had anything to do with running a business. That's not something we normally look at when we're looking at our commercial enterprise. We're typically looking at financial issues. Although if a person did in fact have a criminal history that might impact the safety or security at a particular commercial business, I can tell you I think that would probably be pretty relevant. With the increase of the new and additional marijuana dispensaries, that may be something we're going to have to seriously look at. But the particular paper that they sent out did not include anything specifically for commercial. They did say they believe that it's an absolute fair housing violation to ban someone based on arrest alone, arrest that never ended in a conviction for someone. If there's an open arrest, they left that really unanswered, but I would say if there's an open arrest for the type of crime that might be a risk to your other residents or to your owner, I would guess that we believe currently you could now ban them until that arrest has been completed. Either they were found not guilty or they were exonerated completely and the charges were dismissed. Another issue we need to talk about, but besides just the rental criteria, is what all is included in the lease. Please be careful if in fact you are using an AAR lease. I frequently see that the realtors fill this out wrong. If you look where it says electricity, it says all utilities are included except, and you will see where a licensee is written in none. Well, that may make a tenant believe that no utilities are to be paid by the owner or that the landlord is going to be paying for all of the utilities. So be careful how you write that. If you want to say the tenant's responsible for all and the landlord is responsible for none, you say there are no exceptions to this particular paragraph. So be careful what you're writing in that. Also, if there's some kind of unique issues about the property like palm trees, that's not something we normally want a tenant to be responsible to maintain. On the typical AAR lease, you see there's a couple boxes for routine is the keyword, routine maintenance issues, routine pest control issues, routine yard issues, routine pool issues. So please make it clear to the tenant what you believe is is routine and what are the issues that they're not going to be responsible for. One of the best tools out there really is the Renter's Advisory. This is also a great document created by AAR that reminds a tenant what they need to look at before they actually sign a lease. What should be relevant to them. Remember, we're talking about disclosure. Even if you do not use an AAR lease, you really should consider using the Renter's Advisory form that explains to the tenant things like where they can get a copy of the Landlord-Tenant Act, what duties they have to go look into issues that might be something that's material to them that potentially the landlord's agent is not something that they can disclose. And we'll talk about that in just a few minutes. So this is a great tool. Please look at it, understand what it is, and if you are a realtor who's representing a tenant, please make sure that you provide this document even if the landlord's agent does not. So let's go to the big question. So what's material and who decides what is material? And here's the answer. R4 281101B says it's the person who is the person who's getting the benefit of that contract. It is the tenant in this scenario that you need to think about disclosing to. What and how to disclose it is not always as easy to figure out. So let's start with the beginning. The most important document is the lease agreement. You are not required to use an AAR lease, but please use a good lease. I believe that the leases that are on the internet have lots of things that are missing. They are not Arizona specific. Arizona has a statute that says you are required to include specific terms, and if you don't, or if you include prohibited terms, there's automatic liability. So think about starting with a really good lease. I'm presuming the people listening to the webinar are probably all licensees, so hopefully you already have access to all these forms. They're all in zip forms, so it's real easy to go in and use. But this particular document is the very first and most basic form of disclosing all of the relevant facts. In the Residential Landlord-Tenant Act, the ARLTA, we have an additional disclosure requirement for multifamilies only. This particular statute, 331319, is what we call our bed bug statute. When they wrote the statute, they specifically said that a landlord is required to disclose and provide educational information to all tenants at the time they move in. However, this particular statute also says that single-family homes were excluded. While I understand the reasons why that was included in the statute, I encourage all of my clients to just use some good educational information, because tenants frequently don't move from single-family home to single-family home. They frequently move from multifamily, where there's a much bigger risk and epidemic of bed bugs currently. They also don't understand that you can get bed bugs everywhere. They are in not just hotels. They are in movie theaters. They are in police departments, hospitals, restaurants. They really are everywhere. So it really is a better idea to explain to everyone who's going to use someone else's house of all the places they can accidentally pick it up, including brand new furniture stores. One of our hottest issues with bed bugs right now is that we have found them in moving trucks. So when a person doesn't have bed bugs, they move it from their present home to your rental property, and your rental property never had bed bugs, and the tenant never had bed bugs, and suddenly they have a bed bug issue. We've been able to track it down to the rental trucks because they don't go in and take any special steps to eradicate something. And if you think about it, that's how people are getting rid of infected materials also. Even brand new moving companies or brand new furniture companies have figured out if they're buying this brand new furniture, they've frequently taken away an old couch or an old piece of furniture, and we have found bed bugs in those items. So think about using a really good bed bug educational information. They're on the internet. They're also on our website for free. But think about including that as part of your disclosure to your tenants.
So Denise, the recommended bed bug brochure available on your website. What is your website?
Website is www.thewordoctor, DOCTOR, then the word evictor, E as in Edward, V as in violin, I, C as in cat, T as in Tom, OR.com. And we have that. We have quite a few suggestions, especially if you're going to use the AAR lease, that are suggested phrases and clauses and addendums that you might want to think about adding to the basic lease. And they're free. You don't have to use us. They're free for everybody. So please feel free to go on and just download those documents. The other disclosure issue is where the tenant's money is being held. As we all know and are rather embarrassed to continue to talk about, there have been some property managers that have embezzled the trust funds. These are tenants' security deposits as well as some rent monies. It's important that you understand where you are required to hold these monies, but it's also important for you to disclose to a tenant that you are holding their money separately. If you are a lease-up a landlord only or landlord's representative only, where you write the lease only, make sure it is very clear to the tenant that you do not hold those deposits, that you wrote the lease only, and that at the end of the lease, when it's signed and executed, at the end of that lease-up process, the owner is holding all of those monies and that you're no longer part of that process and any representation of the owner at that moment. The move-in forms, Arizona law requires that you provide a tenant a move-in inspection form. That is part of the statute. If you do not provide them the move-in inspection form, a judge is going to presume that whatever condition they left it is the same condition they found it. If you work in this industry, you know that is rarely the case. So you need to have proof that you, in fact, provided them a copy of the move-in inspection form. I have to tell you, I've been a little disappointed with quite a few property managers because I know you provide it to them. It actually says on your AAR lease that they acknowledge that you provide it, but you take no steps to get it back. The first time I typically see it, if I'm representing you, is at the time we're now litigating the condition of the property. And the tenant says, no, I mailed this to the landlord and it happens to be identical to the condition of the home at move out. Please take more active steps to reach out to your tenants and to recover this form. A simple email that says, hi Mary, by the way, I haven't seen the move-in inspection form. I'm presuming that everything's terrific. Let me know if it is not. That email can be just taken and slipped inside the file, so when the tenant says, no, I returned it, you can show that you followed up and still had not received it. You are also required to disclose in your lease that a tenant has the right to be present at move-out. There's one exception. If the tenant has been evicted for threatening and intimidating behaviors, and you were the victim of that threat, you are not required to allow the tenant to be present. Notifying the tenant that they have the right to be present at move-out is not the same as the tenant having the right to schedule the actual move-out. You just have an obligation to tell them when you're going to be providing that particular move-out inspection. But disclose that at the beginning of your lease.
Is there a particular time that inspection could take place? So if the lease ends at 5 p.m. Monday night, can you do the inspection at 9 o'clock tomorrow morning?
That's a great question. The law does not specifically deal with when a move-out inspection has to occur. The only reference is that you must provide them a move-in form and that they have the right to be present at move-out if they notify you in writing that they want to be present. The time of the move-out does not necessarily have to be at the same time they turn in the keys. If you're in this industry, you know that you can have a number of move-outs all on the last day of the month, and that there's just not enough bodies out there to go in and complete all the move-out inspections. I can tell you that we had a judge recently in Tucson who said that they believed that the owner or the owner's representative had a duty to hire more people to be available on the last day of the month to conduct move-out inspections. That is the first time we've ever heard that. I happen to disagree with that philosophy. Just because they're moving out and returning possession doesn't mean the move-out inspection has to happen on that same day. You might want to look at your lease and see if you have that specific language in your lease. It is not currently on our suggested phrases and clauses, but because of that recent case, we're looking at changing and adding that clause to our suggested phrases and clauses. So our next issue is in the lease. Sometimes I see that owners or property managers disclose that certain items are as is. Make sure you understand that you can't necessarily say that the property is an as-is condition, because Arizona law, specifically ARS 33-1324, which is basically our Bible for landlords and what our duties are to maintain the property, it says specifically that the landlord has a duty to make sure the home is in habitable condition. There are certain items, however, that sometimes are left behind by other tenants, and maybe a landlord wants to leave them there for convenience, but they don't want to necessarily fix it. Specifically, it's typically a washer and dryer and a refrigerator. There is no Arizona law that requires you to provide a washer or dryer or refrigerator to a tenant if the last person left that in, and if you're going to not repair it or repair it solely at your own discretion, make sure that it's not listed in the MLS as one of the amenities, because if it's listed, then you must fix it. And make sure there's a special addendum that says these particular items are in as-is condition and that they're not warranted to be working. Make sure that you are not including in that list items that you must repair. The general rule is if it is already included in the property, it is something that is attached or affixed to the property, you're probably going to have to maintain it. I had a question yesterday when we were doing the boot camp class. What about a built-in microwave that was going to cost 3 times what a microwave normally costs? Can we now provide the tenant with a countertop microwave? And I would tell you yes, but you would still have to provide a microwave. Our next category is stigmatized properties. There are special rules that say certain items cannot be discussed unless your owner provides written confirmation that they will allow you to discuss that. That must be in your documents, on your owner documents that specifically said you cannot talk about these items, or yes, you do have my permission to talk about it. So let's spend a second just talking about what those particular issues are. Death seems to be one of our biggest problems. Some cultures or religious groups have a specific reason why they cannot live where anyone has ever died. It's part of their culture or their religion, and they find this to be a very important issue. On the other hand, there are some places where the property goes for more money. In fact, down in the bayou, there are many signs that say haunted or not haunted, and they can go for a different amount of money, a higher amount of money.
So what happens if the previous owner was murdered in the property? Do we need to disclose that? The neighbor was kind enough to come over and reveal that information, looks like, to the property manager. Does it need to be disclosed?
That's a really great question. And death of any type, murder, suicide, homicide, does not have to be disclosed. It is part of our stigmatized property law. Here's practically what my concern is. If you do not disclose it, the neighbor always will. If you start a rental relationship where the tenant feels like you withheld something that was very important to them, then you're starting an uncomfortable relationship and not based on honesty or what they believe they have the right to know. In this particular scenario, the neighbor has now told you, so maybe you didn't have that information before, maybe you didn't ask because it was just the estate that you're now representing. The concern that I have is that now that you know, you feel compelled to share that information and you legally cannot without your client's written permission. I would encourage you to have a very long conversation with your client and explain that if you do not, others will, so you might as well tell the story and let it be out there. Additionally, if a prospective tenant asks you, you cannot lie. You can't nod your head while you're saying I cannot reveal that, because you are in fact revealing it, so be careful what your facial gestures are. You need to have a ready response for these types of issues, something like, I am not required under Arizona law to disclose certain facts. If it's a material to you, I encourage you to investigate that. Any smart tenant will figure out that that means yes, but you're not allowed to talk about it, but at least it requires them to do their own investigation. That leads us right into the next conversation, which is registered sex offenders. As a parent or as just a human being, you're going to feel very concerned about placing a family with lots of small children right next to right where the next door neighbor is a registered sex offender. You are not allowed to disclose that. You are not allowed to provide them any additional information. Once again, that's why we like the landlord, the tenant advisory form that the landlords provide that says if it's important to you, you need to look that up. Real quickly, if you are a tenant realtor, please do not get on the registry because frequently sex offenders do not register. And by providing them whatever was on that particular list, you may now be liable because they're going to rely on the fact that you looked it up for them. One of the issues we also have is whether the home has previously been occupied with someone with a communicable disease. You are required to disclose if the person had TB, because that is highly communicable. It is not, you cannot disclose it if the person had things like AIDS or other non-communicable diseases. And remember, that means even if they ask. The next issue is whether or not there had been a scene of a felony. The law specifically makes that an additional category of protected information. However, there's one very strong exception, and that is the drug house exception. If it was remediated, you do not have to disclose it. If it was not, you must disclose that, even if your owner says that you cannot. If you were aware, there's a Tucson case where a family moved in to a home that had previously been a drug house. Terrible story where the person showed up, the bad guys, because people who go to prison don't frequently give forwarding addresses to all their other bad guys. And they came in at night, gun to the head of the dad and said, "Where's our drugs?" Dad says, "I have no idea, we just moved in." He kills the dad. Asks the mom. Mom says, "I don't know, we just moved in." Kills the mom and then decides, well, they must not really know anything. You're going to need a very strong discussion with your designated broker before you decide to take on this property because there are some additional and associated risks with representing a house that previously was the scene of a felony, especially a drug house. And of course, I love this. No, I don't have any drugs here at all. If you, in fact, rent a house where the previous people were drug users or it was a drug house, you are guaranteed that all the neighbors will come and tell the newest tenant. So you need to think about how you're going to deal with that and address that situation before you decide to take that listing.
So Denise, how do you know if a house has been a drug house? Is there like a directory, a listing, and how do you know if it's been remediated, and what does remediation entail?
That's a great question. There is no special registry. However, the police will show that there was an arrest there. There are public records about all activity on every house in every neighborhood. Remediation, you can sometimes find on an insurance report. Typically, however, it's going to be something that as a licensee you should be aware of. If all of the drywall was removed, if all of the venting system was removed, if parts of the home were jackhammered out and it has complete everything, probably had toxic mold or was the scene of a drug house. You are on notice if every single thing in that entire house has been remediated. It is incumbent on you to at least ask why was there that kind of remediation.
So this sounds like a really good opportunity to be the source of the source. You don't want to go to the police department and look for records.
That is exactly right. You need to say, if it's important to you, here is a tenant's advisory, and it gives you the specific places you can look to find out any information that may be important to you. If this does not list everything, feel free to conduct your own investigation. In fact, typically a really smart tenant will talk to the neighbors before they actually decide to go in and rent that house. So our next question is, what happens if a tenant asks, or a prospective tenant asks? Can you tell if you actually know? Absolutely not. And you can't tell but not tell by making hand gestures or nodding or pointing to the particular part on the tenant's advisory that you think they should look up. And you cannot lie. So once again, I'm going to encourage all of you, think about already having in your quiver of arrows a pre-thought, pre-planned, pre-practice statement. This is relevant for you. You need to conduct your own investigation. There's certain information I just can't talk about. So our next tool is the Residential Lease Owner Property Disclosure Statement. AAR created this wonderful form that helps an owner understand what their duties are. Advisory is just like the tenant's advisory that tells the owner all the duties the property manager is supposed to do. All the different things that he needs to know as an owner about paying taxes and being registered and licensed and all those things, what we call the lease owner SPUDs. The form is also available on AAR website and as a form that you can download. That is a separate type of form that is like our SPUDs, where an owner fills that out and discloses to tenants all of the potential issues that they know about. A word of caution to property managers: if you are representing an owner who says, I don't know anything and I cannot fill this out, remind them that they know who the owner is. They know the property address. They probably know the zip code. They may know what the utilities are, and they know all of the repairs that you completed for them as the property manager. If they just bought the property as an investment, they probably had SPUDs, so they know something. Separately, I need you to know that you probably want to consider having your own property manager's disclosure form that you supplement if you know that there's certain activities that you completed. This is not a required form, by the way, but it's now become the professional standard of care because your organization of your peers all created this. So I would strongly encourage you to use that and consider a clause in your property management agreement that requires the owner to let you disclose anything that you believe is necessary. So what about previous issues, like the fact that there was a previous bad tenant or the next door neighbor is a bad neighbor? Do you have to disclose these issues? I can tell you absolutely. Disclose anything you would disclose to your grandma. What about pests? What about ants, roaches, scorpions, bed bugs? I suggest that you say we live in Arizona and there are lots of creepy crawlies and that the tenant's going to be required to perform their own pest control services, that you should disclose if this is a pocket or an area that has scorpions, because that's creepy to a lot of people who haven't ever lived in the area, especially certain pockets of Arizona. If it's had bed bugs, you do not have to disclose it if it's been remediated, but you might want to consider having a certificate from a pest control provider that these kind of creatures are no longer in the house. So when do you have to disclose things like the utilities, appliances, where you're going to fix them or not, deposits, fees, who's responsible for what, HOA issues? We're really encouraging you, disclose these up front. Disclose these before you're actually signing the lease. Think about listing those on a separate page so that if I hate SRP and I only want to use EPS, I know that before I've actually fallen in love with the house and want to sign the lease today. The application process is something that we think you should disclose up front. It should be something that's potentially out on your website, what that fee is. Once again, is it per person, per household? What the rental criteria is, what their credit score has to be if they have any issues. List all of that as something you disclose before you actually are sitting down and writing the lease. Also about what's refundable and when it's refundable. Neighborhood issues are something that we all have to live with. Is there a loud barking dog? Have other tenants moved out because of that? Or do we have a problem landlord next door? This is something that you need to think about disclosing, especially if it's been disclosed or complained about by other tenants. Whether the neighbor is this kind of neighbor or just a VRBO house is something we think you probably need to disclose, especially if you've had some complaints in other residents or you're on notice that other residents, other tenants have complained about this particular issue. When in fact, or when in doubt, disclose it. Finally, the last big category is what other unique issues about it, like a senior community. Is there a separate fee to use certain things? Are there a certain number of passes that you can give out and otherwise would cost an additional amount of money? Is there a cell phone issue? Any kind of other issues that might be something that's relevant. This should all be disclosed prior to having the tenant sign a lease. And of course we have the next category, what do I disclose to my owners? I would say everything that may make their life more difficult. So what do we disclose to our owners? The most important is money. They always care about that. What's the rental amount going to be? What deposits are you collecting? Who keeps what deposits or what fees? Late fees, and of course, always important is what is your compensation? How much are you getting paid? Are you keeping administrative fees? Are you keeping some kind of ACH fee? That needs to be disclosed in writing to the owner at the time you're signing and writing a PMA. If that changes, it needs to be written and disclosed to the owner before a new PMA is written. Do you have any separate deals with any vendors? Do you get some kind of kickback if you pay it early, some kind of discount? Bulk discounts, we understand that they exist. You are required to disclose those deals and whether or not you have any relationship with that vendor. How often their reports are going to be done, how quickly they can get a report if they need one, how they can cancel their PMA. As a reminder, don't forget your PMA can auto-renew. You are required to notify them at least 30 days before that date, and you must notify them in writing. The last one is just be careful with your owners. Make sure there's a clean beginning date and ending date, what the cancellation provisions are. How are you disposing of that money when the reports are coming? How often can they get one like in the middle of the year? What you're going to use the reserves up for? Do they have to replace those reserves? And whether or not your PMA can be assigned. So now we have the time for questions. I see there's quite a few coming up, so let's talk about some questions you all have.
Let's go back to the one question. Seems like we've got a couple of them here. The barking dog. Is it better to call the barking dog line through the city or just let the owner know?
If you're having complaint from your tenant there's a barking dog, report it to that particular city so that you get rid of the issue and don't just pass it on and now have a problem with the new tenant. Report it to the owner so that they understand there's a concern. But as a property manager, you have the right to make that report yourself.
And what about feral cats?
Feral cats are just live in Arizona. I can tell you that's not something that most of us feel like you have to be disclosed any more than the fact that we have ants and roaches in Arizona. They exist just like pigeons. Unless you have an unusually large issue where you've had repeated problems, then you probably need to disclose that.
So the new information that's coming out on the felony guidelines for tenancy, where can somebody find that information online?
That's a great question. We actually have on our website under hot new issues, we always go in and have a new hot button about anything that's a major issue, especially for property managers. So we have a summary of that very complicated guidance and also some suggestions or some examples of what kind of criteria, time frames, and categories you might want to consider.
So have you heard anything more, or is the audits for record keeping, is that still a hot button with ADRE?
Yes, they have let us know that everyone who's in the property management industry will be audited. If you haven't been yet, you will probably be by the end of 2017. So get your records in order if you haven't done so yet.
Wow. If appliances are in pictures as advertised in the house, would they then be considered included, and do they need to be warranted?
Okay, so if there's just a general picture of that particular kitchen or a picture of that area, it would be reasonable for a tenant to believe that it is included and that it is warranted. So if you're going to have it in a picture, you need to have a specific clause that says the following appliances are not included and not warranted, although they may be on site.
Excellent. And then are contractual rent escalators legal?
No. Well, let me make sure I understand your question. So there are written in commercial leases clauses that say at any certain period of time the lease automatically escalates. That is found in commercial. We have had many judges in residential say that that is not reasonable because the market should adjust to whatever that rent is. So I would tell you, don't think about adding something in, especially because you're going to bind your owner. And right now we're able to raise our rents, and if you had them locked into a lease for the next 3 years where they're going to lose quite a bit of money, they're going to blame you because you're the person who had the crystal ball and was supposed to figure out the future.
Excellent question, Sam. Thank you. Okay, so how does the whole drug house issue work if it happens to be an apartment building? Can the tenants tell the new tenant that it was previously used for drugs, and does the property manager have the duty to disclose the new tenant, to the new tenant?
Okay, so all of the stigmatized property laws include for apartment communities, by the way, so they're not separate just for single-family homes. If the apartment's been remediated, there is no duty to disclose that. Remember, the duty to disclose is something different than the business decision that you probably need to disclose because the other tenants are going to tell. So that's why you need to have a very clear conversation with your owner in writing what needs to be disclosed and what can be disclosed, and why they might want to give you written permission to do so.
So talking about one tenant to another tenant, having that conversation. So what happens when tenant that's been living there goes to the new tenant and says, oh my gosh, did you hear that the people who lived in this apartment before you had bed bugs and they were terrible and they were crumbing out of the outlet covers and everything? Does the new tenant have a fallback? Can they come to the property manager and say, oh my gosh, you didn't tell me?
I can tell you that as long as you have proof that it's been resolved and that you got a clean bill of health before they moved in, they can come and talk to you about it, and you would show them your documentation. But if it's been totally eradicated, you don't have a special duty to disclose that unless there's pockets in your particular area. We're talking about scorpions, maybe some beehives. We've got roof rot issues. There are some very specific issues that you might want to disclose if in that particular house you've had a particular issue.
So Denise, pulling out your crystal ball. So we've had the audits that have come up and they're really not going to go away for a while. What do you foresee on the future? What do you think is going to be the next hot topic?
Well, we believe that one of you, I'm sorry to tell you, is going to be sued this year for your felony guidelines, for your felony rental criteria. I'm hoping it's none of you who are listening. I'm hoping it's the person who's not paying any attention and not appearing, going to any classes and learning everything. Hopefully you're all paying really close attention to this. I think that if you have any policy at all, you will not be the first person sued. In fact, you'll probably be fine because they can't really tell us for sure who's a good felon and who's a bad felon. It's when you have a complete no felony policy forever and didn't think about that happening 35 years ago versus last year. So please, that's the hottest topic for me. I think you need to be right on top of that. I know we have some new issues coming up with recreational use marijuana that might be an issue. You have the right to not allow that, just like you can prohibit smoking. You might want to think about writing that into all of your leases right now. We also have some other issues coming up with whether or not we're going to have to use standardized forms and not use our AAR forms. That's in front of the Supreme Court right now. We expect a ruling on that sometime within the next few months.
Excellent. Okay, so two more questions. Can a tenant be evicted based on the issue that his dog was left unleashed?
Absolutely. So you need to provide a 10-day noncompliance to a tenant that the animal was unleashed and not under control. That is a city code that is required. You give a 10-day noncompliance. If it happens again within the 10 days, you evict at the end of the 10 days. If they start taking care of the issue but it happens again, you can give a second 10-day noncompliance, which terminates the lease for the second issue. That second notice is not curable.
Excellent. And then can a property manager fill out the rental SPDS?
Can you? Yes. Should you? Absolutely not. That is a document that was prepared for owners. It is to protect you. Please do not take that liability and put it on your back. In fact, brokers, if you're listening, issue a policy that says you shall never fill that out. You may have a separate page that supplements, especially if the owner won't tell the truth, but you should never, ever fill that out on behalf of your owner.
Absolutely. Well, Denise, thank you so very much for joining us today.
Thank you for having me. You guys have a great day.
Have a great day, everyone.